And joining us now is criminal attorney Arthur Aidala. Thank you so much for being here with us.
Thank you so much. Just hearing that real quick, like when you're a criminal defense attorney and your client is outside saying these bad things about the judge, and then you got to walk in there later that day or the next day. I had a client like that. He was a New York billionaire. And I mean, he was saying the nastiest, meanest things to me, but loud enough that the judge could hear it. And I just was like, Mr. Hirschfeld, do you realize that this judge, if you get convicted, number one, has your life in your hands, but number two, there's so many rulings that he has discretion over between now and the end of the trial. Like, why are we ticking him off? And I'll tell you what he said. If that judge was so smart, he wouldn't be sitting up there. He'd be making all the money I just paid you, and he'd be sitting down here. So yeah, Todd Blanche has got a really rough road ahead of him.
Your reaction to the judge actually calling Trump in contempt of court.
What's up, folks? Dr. John Podcast is back. So what just happened, guys? For 2 years, the question has been the same. Someday the courts will reach a conclusion. Someday the accountability mechanisms will produce a real consequence. Someday the gap between what Trump does and what happens to him will finally close. And for 2 years, that someday has felt permanent, like a horizon that keeps moving back every time you step toward it.
This gag order.
I mean, look, it's not surprising. The judge kind of set himself up to be in this difficult position. Anytime you put in a gag order, you have to be able to back it up. It's like a parent with a child. You know, if you don't do this, I'm going to take away your phone. Well, then you got to take away the phone. The problem is here, the judge doesn't have that much power. I mean, $9,000, Lindsay, I mean, what is that doing for Donald Trump? And I think, and this is just a guess, if he put Trump in jail even for 6 hours, like Trump, that's exactly what Trump wants. I mean, it will be international news.
So you don't really think that that's a possibility? I mean, I know he has the power, but you're saying you don't think he's going to actually act.
You also have to look at Donald Trump, the individual. Forget about, or any individual in that position, a 77-year-old man who's never been in trouble in his life, in the lowest level crime, felony crime, a white-collar crime with no victims.
Like a promise that never quite arrives. But something has quietly changed. The courts have stopped relying on Trump's good behavior. They have stopped assuming he will eventually comply. They have started writing orders that do not require his cooperation. Orders that have already spelled out the violation, already pre-approved the enforcement, already warmed up the machinery.
You know, judges are very, very reluctant to put someone like that in prison for a minute.
Trump called the judge with this gag order totally unconstitutional. Your response to that?
Well, it does infringe on someone's rights. I mean, people confuse the First Amendment. The First Amendment has to do with government trampling on your rights to speech. And this is the government doing that. It's a balancing test. And, look, it's very frustrating when you're accused of something and other people are out there beating you up and you can't reply to it. It's a difficult position for a lawyer to be in. When I tried the Harvey Weinstein case, that was the position we were in. We weren't allowed to say anything, but the complaining witnesses, lawyers, the likes of Gloria Allred, were out there every day beating the heck out of us, and we could not retort. In fact, I did a short radio interview with the late Imus in the morning, Diane Imus, and I got called in the next day, and I got yelled at, and all I was talking about was how jury selection takes place. I didn't do what Trump did. So, judges should really be very...
So that when Trump crosses the specific line the order describes, the gap between the crossing and the consequence is not weeks or months of new hearings, new appeals, and new delays. It is hours, maybe less. That is what the instant order concept is actually describing. Not a surprise SWAT raid in the middle of the night. Not a secret warrant signed in a back room. The removal of the procedural runway that has been the primary tool of the delay strategy.
Very tight before they just hand out these gag orders, especially when it's hard for them to ultimately enforce them.
Your reaction to what's played out in court so far?
They're laying the groundwork. I mean, they're laying the groundwork because their base of the prosecutor's trial has to be so strong, like solid, like you're building a skyscraper, not a house, a skyscraper, because when Michael Cohen comes in, that's a hurricane, an earthquake, a tornado, all wrapped into one. I mean, they're going to cross-examine the heck out of him, unlike almost every other every other witness that you see testifying. But hundreds of prosecutors have gotten convictions before with horrible people as their main witness. So it doesn't eliminate them, but they need to be on very strong grounds when he takes that stand.
And before I let you go, as we were discussing during Aaron's piece, is it really damning for Trump that, at least the allegation on the witness stand was that he really didn't care about keeping Stormy Daniels quiet until after the Access Hollywood tape, weeks before the election?
Yeah, and that because then in the prosecution summation, they're going to say, although you just heard our colleague, the defense attorney, say this was about his family, the timeline doesn't add up. He doesn't get excited about this. This doesn't get any traction until his sex life and the way he treats women really become part of the campaign after the Access Hollywood tape. That's how you know, ladies and gentlemen, beyond a reasonable doubt, he was only doing this for the election. And if that's true, you have to find him guilty.
Arthur Aidala, always appreciate your insight and your time.
Judge Merchan's written warning that future gag order violations will be punishable by incarceration is not a threat waiting to be executed through a lengthy new proceeding. It is a pre-authorized enforcement order waiting for the trigger. The Supreme Court's refusal to shield Trump from criminal process is not just a legal holding. It is permission for every lower court to treat him the same way they would treat any other defendant who defies orders, including with immediate arrest. The instant order is the legal infrastructure the courts have been quietly building, and Trump is scared of it because the courts are done waiting for him to decide to comply. Let me be absolutely clear about what the instant order concept is and is not, because accuracy matters, and we do not do fiction here. There is no single specific court order that says if Trump does X, marshals will arrive at his door within the hour. No single document signed by a specific judge with a specific docket number posted in a public court filing. That specific document does not exist. If you have seen videos claiming that such an order exists and has been signed and is ready to execute, those videos are either fictionalizing the situation or dramatically overstating what is in the public record. What does exist and what the instant order concept is capturing is something more distributed and more systemic than any single document. It is a legal infrastructure built across multiple proceedings in multiple courts, through the accumulation of written contempt warnings, through Supreme Court signals, through enforcement preparation, all of which collectively means the gap between Trump crossing specific documented lines and facing specific documented consequences has become much shorter than it used to be, not because of any single order, because of the way the entire enforcement picture has been assembled around him over the course of his second-term legal battles. And that assembled infrastructure is real, it is documented, and it is as dangerous to the delay strategy as any single dramatic court order. Let me walk you through exactly how the infrastructure was built, piece by piece, and why each piece makes the overall enforcement picture more immediate and more credible than it was before. Because understanding the mechanics is what turns the scary arrest narrative from clickbait into something you can actually use to understand where things are headed and why Trump's legal team is calculating their options differently than they were a year ago. Let me start with Judge Merchan's contempt progression. This is the most documented and most specific piece of the instant order infrastructure. 10 contempt findings, each one documented individually, each one based on a specific statement or posting that Merchan reviewed against the specific terms of the gag order and found to constitute a deliberate violation. $9,000 in fines reaching the statutory maximum, and then the written order stating explicitly that future violations will be punishable by incarceration of up to 30 days per offense. That progression is the enforcement infrastructure being built in real time. And what each step in that progression does is remove a procedural layer that would otherwise have to be completed before the next consequence can be imposed. Here is how that works mechanically. Before the first contempt finding, any allegation that Trump violated the gag order would have required a full hearing, argument from both sides, a judicial determination of whether a violation occurred, and then a determination of what penalty was appropriate. That process takes time. It can be delayed. It creates multiple procedural opportunities for the defense to slow things down. But after 10 documented findings, after the court has individually reviewed and documented 10 separate violations, after the judge has written a formal order saying fines have been exhausted and incarceration is next, the next violation does not start from scratch. It starts from a pre-established baseline of 10 prior documented violations. A written judicial acknowledgement that the defendant has demonstrated a pattern of deliberate noncompliance and a specific, pre-announced consequence that the court has formally committed to imposing. The procedural runway has been compressed by everything that came before. The 10th violation did not require the court to determine whether a pattern of violations existed. The pattern was already documented. The 11th violation is not starting from zero. It is starting from a court record that says this is the 11th time, and the consequence for the 11th time has already been determined and announced. That is the instant in the instant order, not that the consequence literally happens in an instant with no process at all, but that the process required to impose the consequence has been dramatically compressed by the prior proceedings that built the record. What would have taken weeks or months of new proceedings to establish from scratch can now be executed in hours or days because the foundation work has already been done. The violation triggers a pre-built enforcement mechanism rather than initiating a new proceeding from the beginning. Now let me talk about the Supreme Court dimension, because this is the piece that gives the lower court enforcement infrastructure its authority to operate without constantly looking over its shoulder at the appellate process. When the Supreme Court refused to halt Trump's New York criminal sentencing, it made a specific statement about how Trump should be treated in the criminal process. The statement was made through the decision itself, not in explanatory language, but the legal community read it clearly. The Supreme Court was signaling that Trump is not entitled to special procedural treatment as a former or sitting president when it comes to the enforcement of criminal judgments and contempt orders. He is a defendant like any other defendant. The contempt enforcement mechanisms that apply to any other defendant who has demonstrated 10 documented violations of a court order apply to him. And courts do not need to be cautious about enforcing those mechanisms on the theory that the Supreme Court might intervene to protect him, because the Supreme Court has already shown that it will not intervene to protect him from ordinary criminal process. That signal is enormously important for the psychology of enforcement. Courts facing unprecedented enforcement decisions about politically prominent defendants are always calculating the risk that the enforcement action will be reversed on appeal or blocked by a higher court. If Merchan imposed an incarceration order and the Supreme Court immediately halted it, the credibility of future enforcement threats would be dramatically diminished. But the Supreme Court has already demonstrated through the sentencing decision that it is not going to step in as a political protection mechanism for Trump in the criminal process. That demonstration changes the risk calculation for every lower court judge who is considering whether enforcement actions will be sustained. The instant order infrastructure is credible, not just because it has been built carefully through documented proceedings, but because the Supreme Court has effectively signed off on the approach by refusing to obstruct it. Let me also talk about what pre-approved enforcement language means, practically in terms of how quickly consequences can flow from a violation. In normal contempt proceedings, after a violation is alleged, there is a process. The court schedules a hearing. Both sides file briefs. The judge considers the arguments and determines whether a violation occurred and what the appropriate remedy is. That process has a minimum timeline measured in days or weeks, but when a court has already issued a written order that specifically says the consequence for the next violation is X, and has already established through prior proceedings that the defendant has a documented history of deliberate non-compliance, the hearing that would otherwise be required can be much shorter, not because procedural due process is being eliminated, because the due process work has largely already been done. The defendant has already had the opportunity to be heard on the prior violations. The court has already determined through multiple documented findings what the pattern of conduct looks like. The pre-approved enforcement language reduces the incremental process required for the next violation to the minimum necessary, rather than the full process that would be required if no prior proceedings existed. And the New York City Department of Corrections confirmation that it is aware Trump could be jailed and is making any necessary arrangements is the operational confirmation that the enforcement infrastructure is not just legal, but logistical. Courts are legal institutions. They need operational support to execute incarceration orders. The fact that the Department of Corrections is aware of the scenario and is preparing for it means the operational gap between a written incarceration order and its physical execution has been addressed. When Merchan writes an incarceration order for a future violation, the marshals who would execute it have a prepared facility. The operational preparation is itself a signal that this is being treated as a real scenario requiring real preparation, rather than an abstract legal threat that no one actually expects to be executed. Now let me think about what the accumulation of all of these pieces means for the delay strategy that has been the central tool of Trump's legal defense across all of his second-term cases. The delay strategy depends on a specific operational model. Every step in a legal proceeding takes time. Every appeal takes time. Every new hearing takes time. And by generating enough steps and enough appeals and enough new hearings, you can extend the total timeline of legal proceedings far enough that something changes. An election, a change in political circumstances, a different prosecutor, some external development that makes the proceeding moot or provides political grounds for dropping it. The delay strategy has worked at least partially in every case where it has been employed because the American legal system has minimum process requirements that create irreducible minimum timelines. But the instant order infrastructure is specifically designed to minimize the delay opportunities at the contempt and enforcement end of proceedings. It does not eliminate all delay. Trump's legal team can still appeal a specific incarceration order. They can still file emergency applications. They can still try to get stays. But the work that used to have to be done to establish the basis for enforcement has been done in advance. The 10 documented violations, the written order, the Supreme Court signal, the Department of Corrections preparation, all of that prior work means that when the triggering violation occurs, the enforcement mechanism can move faster than the delay strategy can respond to it. Not instantaneously, but faster than the model requires to work. Here is the ultimate significance of the instant order infrastructure for Trump's behavior and legal strategy. The existence of a credible, pre-built, operationally prepared enforcement mechanism changes the calculation about what behavior is safe. When the consequence for a specific violation is a hypothetical that would require months of new proceedings before materializing, the cost-benefit analysis of committing that violation is one thing. When the consequence for a specific violation is an operationally prepared enforcement mechanism that can execute within hours, the cost-benefit analysis is something very different. Trump knows this. His legal team knows this. And the behavioral evidence that he is taking it seriously is in the fact that even with all the political incentives toward continued defiance, the violations that were occurring at a documented rate have not escalated at the same pace in the period after the written incarceration warning was issued. The infrastructure is doing work even before it has to be activated. Let me give you 3 points that explain exactly why the instant order infrastructure represents a genuinely different legal reality for Trump than anything that existed before it was assembled. The 10 documented contempt findings and the written incarceration warning have fundamentally changed the procedural landscape for future enforcement by establishing a pre-built baseline that compresses the process required to impose consequences. Before the 10 findings, any enforcement action would have started from scratch. After the 10 findings, any new violation starts from a documented record of deliberate non-compliance that has already been individually reviewed and formally found to constitute intentional violations. That record changes everything about the procedural efficiency of future enforcement. The work that would have taken weeks to establish is already done. The pattern is documented. The court's assessment of the defendant's relationship with compliance is written into the official record, and the specific consequence for the next violation is pre-announced in a written order that commits the court to its own stated trajectory. The instant order is not one thing. It is the accumulated legal work of 10 prior proceedings that has been built into the enforcement infrastructure. The Supreme Court's refusal to intervene in Trump's criminal sentencing process is the permission structure that allows lower courts to implement the enforcement infrastructure without the chilling effect of uncertainty about appellate intervention. Courts are not just legal institutions. They are institutional actors making decisions under uncertainty about how higher courts will evaluate their actions. A lower court judge who is uncertain whether the Supreme Court will intervene to block an incarceration order has rational reasons to be cautious about issuing one. But the Supreme Court has demonstrated through the sentencing decision that ordinary criminal process applies to Trump and that it is not going to act as his political protector in that process. That demonstration removes the uncertainty that would otherwise make lower courts cautious. The Supreme Court has effectively told every lower court with a Trump-related enforcement question that they should treat him like any other defendant. And treating him like any other defendant with 10 documented contempt violations and a written incarceration warning means the enforcement infrastructure is fully authorized to operate as designed. The Department of Corrections' operational preparation for a possible presidential detention is the most concrete evidence that the instant order infrastructure is being treated as a real scenario requiring real preparation rather than a rhetorical threat that no one expects to execute. Government agencies prepare for real scenarios. They do not make necessary arrangements for abstract legal theories. When the Department of Corrections confirms that it is aware Trump could be jailed and is preparing accordingly, it is saying that the people responsible for the operational execution of incarceration orders have evaluated the legal trajectory and concluded that the scenario is real enough to require operational preparation. That institutional assessment, made by people whose job is operational reality rather than legal theory, is the most credible available signal that the instant order infrastructure is not just legal scaffolding. It is a functioning enforcement mechanism with the operational support necessary to actually execute. Let me add something about the psychology of the situation from Trump's perspective, because understanding his fear requires understanding what is different about this specific enforcement configuration compared to everything that came before it. Trump has survived many legal threats through his career and through his first and second terms. He has survived them primarily through two mechanisms. First, the length of the legal process. The longer things take, the more opportunities there are for circumstances to change. Second, the financial manageability of the consequences. Fines, even large fines, can be absorbed by someone with Trump's resources and fundraising apparatus. They become political assets. They become proof of persecution. They generate donations. The consequences that have been imposed through the legal process so far have been financially manageable and temporally distant. But the instant order infrastructure is specifically designed to attack both of those survival mechanisms simultaneously. It attacks the temporal distance by compressing the gap between violation and consequence through the prior proceedings that built the baseline. And it attacks the financial manageability by putting the consequence in a category that cannot be fundraised. You can raise money to pay fines. You cannot fundraise to get out of jail. Physical detention is not a consequence that can be converted into a political asset by selling it as a persecution narrative. You can try, but the image of a sitting president in a jail cell is not the same as the image of a sitting president paying a fine. One is an inconvenience that generates sympathy. The other is a visual that fundamentally changes how millions of people perceive the man they are looking at. That image, the image that the Department of Corrections' necessary arrangements are prepared to make possible, is a specific thing that Trump's entire political operation has been built to avoid, not the legal consequence in the abstract. The image, the optics, the permanent transformation of the public perception of whether he is powerful or contained. That is what the instant order infrastructure threatens, and that is why he is scared. Now let me think about what the instant order infrastructure means for the other people in Trump's orbit who are making their own calculations about their legal exposure and their loyalty. Because the enforcement infrastructure does not just affect Trump, it affects everyone who is calculating how much personal risk is acceptable in service of maintaining loyalty to the administration. When the consequences for contempt of court were fines that Trump's supporters cheered and his enemies lamented, the loyalty calculation for officials and allies was simple. Stand with Trump. Accept the political heat. The legal consequences are manageable. But when the consequences for contempt of court become incarceration that has been operationally prepared by the Department of Corrections, the loyalty calculation changes. Because incarceration is not manageable through fundraising and political solidarity, it is not a consequence that can be converted into a demonstration of fighting for the cause. And the officials and allies who are calculating their own exposure to contempt findings and compliance orders are now doing those calculations against a different denominator than they were when the worst case was a fine. The Kash Patel situation is the most relevant example. Patel, operating as FBI director, was placed in a position where his loyalty to Trump conflicted with his legal obligation to testify honestly under immunity. The immunity order made the legal cost of lying higher than the cost of telling the truth. And the enforcement infrastructure, the knowledge that courts were treating Trump's situation with the same tools available for any other defendant, was part of the context in which Patel made his calculation about what compliance required. The instant order infrastructure is not just about Trump's direct exposure. It is about the exposure of everyone in the ecosystem of loyalty who faces a similar choice between compliance with court orders and loyalty to a president whose legal situation is no longer protected by the gap between violation and consequence that used to make loyalty relatively cost-free. One final thing about the broader significance of this enforcement moment. The instant order infrastructure represents something important about the resilience of the American legal system under stress. The system was not designed to handle a situation where the most prominent defendant in the most important cases is also the sitting president with political motivation to resist compliance and political resources to sustain that resistance. The existing tools were not perfectly calibrated for this scenario. Fines that are manageable, delays that can be extended, appellate processes that can be weaponized for time buying. The system had gaps that the delay strategy exploited, and the courts have been adapting to close those gaps. 10 contempt findings to build the baseline. Written incarceration warnings to pre-announce consequences. Supreme Court signals to authorize ordinary process. Department of Corrections preparations to make operations ready. The system is adapting in real time to a threat it was not perfectly designed to handle. And the adaptation is working. Not perfectly, not instantaneously, but the gap that the delay strategy has been exploiting is getting smaller. And the instant order infrastructure is the most visible expression of that closing gap. Here is exactly where we stand. Judge Merchan has documented 10 separate contempt violations, reached the statutory maximum for fines, and issued a written order stating that future violations will be punishable by incarceration of up to 30 days per offense. The Supreme Court refused to shield Trump from ordinary criminal process in the sentencing decision, effectively telling lower courts they can treat him like any other defendant, including with immediate arrest when he defies orders. The New York City Department of Correction confirmed that it is aware of the potential detention scenario and is making any necessary arrangements. The combination of documented prior violations, pre-announced incarceration consequences, Supreme Court authorization, and operational preparation represents a legal enforcement infrastructure that has been assembled specifically to minimize the procedural runway that the delay strategy depends on. Trump is not scared of a surprise SWAT raid. He is scared of an infrastructure that has been built specifically to compress the gap between violation and consequence to the minimum that the law permits. The instant order is that infrastructure, and it is ready. The someday that felt permanent has quietly become something closer. Not tonight, necessarily, but not someday in the abstract either. The infrastructure is built, the baseline is documented, the Supreme Court has cleared the way, the Department of Corrections is prepared, and the next time Trump crosses the specific documented line, the gap between the crossing and the consequence is measured in hours rather than months. That is the real story of the instant order, not a dramatic single moment, the quiet assembly of an enforcement mechanism that has made the accountability that used to feel perpetually distant feel suddenly close. And that closeness is the thing that is changing calculations in Trump's legal team and in the broader political world about what the future of this presidency actually looks like.